Has someone ever told you you need a trust? Maybe your parents have a trust. Maybe you've heard the term tossed around and assumed trusts are only for the ultra wealthy. But what is a trust, really? What does it actually do, and what doesn't it do? In this episode, I'm breaking it down in plain terms. When a trust makes sense, who can benefit from a trust, and how to decide if one fits your situation. Welcome to the Death Readiness Podcast. This is not your dad's estate planning podcast. I'm Jill Mastriani, former estate attorney, current realist, and your guide through wills, trusts, probate, and the conversations no one wants to have. If your Google search history includes, "Do I need a trust?" What exactly is probate? And am I supposed to do something with mom's will? You're in the right place. When someone starts talking about something you think you should understand, but don't, it's tempting to just nod along and pretend. We all do it. In my first year practicing law, I worked with Harlan Dotson, one of the most generous teachers I've ever had. From the beginning, Harlan made it clear that we were on the same team. One day, on the way to a client meeting, he said, "We need to get copies of all of their Schedule K-1s." I had no idea what a Schedule K-1 was. Then he looked at me and asked, "Do you know what that is?" I wanted to say yes. I wanted to nod in affirmation, but I didn't. And without skipping a beat, Harlan explained exactly what a Schedule K-1 was and why it mattered. That moment stayed with me, not just because I learned something new, but because it reminded me how powerful it is to admit what you don't know and get clarity. So if you're listening today and don't quite understand what a trust is, or if you've nodded along in the past pretending to get it, stick around. In this episode, I'm going to help you understand a common type of trust from the ground up, just like Harlan helped me understand Schedule K-1s. Today, I'm answering a question from a listener named Lauren. Lauren is a working mom with 3 kids living in California. And like so many people, she's been told by everyone, friends, family, even her neighbor's uncle, that she needs a trust. Lauren's problem is that she doesn't really understand what a trust is or why she would need one. She asked if I could walk her through it, what a trust really is, and what it actually does. There are plenty of people who feel qualified to say, "You need a trust," but often they can't explain why. A trust isn't inherently good or bad or for the wealthy or for the poor. It's a tool, like a hammer. A hammer is a great tool if you have a nail, but it's not much help if you're trying to turn a screw. Trusts work well in the right situation. And trusts are a deep topic, so I'm going to speak in general terms today, with the understanding that there might be exceptions to some of these general rules. Let's start with the basic definition of a trust. A trust is a legal arrangement where one person, the trustee, holds and manages assets for the benefit of others, known as beneficiaries. This arrangement is laid out in a trust agreement, which acts like a contract between the person who created the trust, called the grantor or the settlor, and the trustee. The agreement spells out who gets what, when they get it, and under what conditions. Today, we're going to talk about one kind of trust, a revocable trust, which is a trust that can be revoked or changed. We're going to talk about a revocable trust today because it is the most common type of trust, and because it's the type of trust that Lauren from California is asking about, even though she might not have realized it. I'm going to start by telling you what revocable trusts that can be revoked, do not do. Revocable trusts do not save you money on taxes. Revocable trusts do not protect your assets from creditors. There are other types of trusts that do that, but that's a topic for another day. Next, let's talk about 2 reasons someone might use a revocable trust and who might benefit from having one. Then we'll talk about what a revocable trust actually looks like. Reason number 1 for using a revocable trust. You want to make it easier to manage your assets, now and in the future. A revocable trust allows you to place all your assets in one central spot, so it's easier to keep track of what you own. And if you ever need help managing things, whether from an adult child, a trusted friend, or a professional, it can make that process much smoother. This isn't just for people with huge estates. You might have modest assets, but still need help managing them, maybe because of illness, age, or cognitive change. A revocable trust can offer a simple, clear structure for that kind of support. Reason number 2 for using a revocable trust. You want to avoid probate. Avoiding probate is the most common reason people create revocable trusts. Probate is the court-supervised process for distributing your probate assets after you die. It doesn't apply to everything you own, only to what's in your individual name without a beneficiary or payable on death designation. For example, let's say I have a bank account in my name. If I fill out a payable on death form and name a beneficiary, for example, my husband, that account bypasses probate and goes directly to the person named. Here, it would pass directly to my husband. But if I don't fill out that form, the account becomes a probate asset. It will be distributed according to my will, if I have one. If you want to dive deeper into probate and what counts as a probate versus a non-probate asset, you can check out my short video at deathreadiness.com/will, W-I-L-L. Whether avoiding probate matters depends a lot on your state of residence. In some places, probate is expensive and time-consuming. In others, it's not a big deal. Here are 4 situations where avoiding probate might make a lot of sense. Situation number 1. You own real estate in more than one state. For instance, if I live in Michigan but own real estate in Tennessee, my estate would have to go through probate in Michigan and in Tennessee, what's called ancillary probate. If a revocable trust owns the Tennessee real estate, it can avoid the need for that second round of probate, ancillary probate, in Tennessee. Situation number 2, you want privacy. Probate is a public process. If you have a will, it becomes part of the public record. When a will is part of the public record, it means that it can be accessed by the general public through the probate court in the county where you lived at your death. That might not matter to you, but if you have a blended family or complicated relationships, you might prefer to keep things private, and a trust can help with that. Situation number 3, you want to avoid court delays. In some states, like California, getting a hearing in probate court can take months. That means your loved ones might have to wait a long time before they can access your assets or move forward with next steps. If you want things to be handled more efficiently and without court involvement, a revocable trust can help bypass those delays. Situation number 4. You live in a state where probate fees are based on a percentage of the value of your assets. In some states, the cost of probate isn't just court filing fees and hourly attorney's fees. It's calculated as a percentage of the value of everything that goes through the probate process. That can add up fast, even for a modest estate. Using a trust can help minimize or avoid those fees altogether. If you live in California, like Lauren, who provided today's question, does, avoiding probate can save your family a lot of money. California law sets the fees that both the executor or personal representative of your estate and the attorney for your executor can charge. And those fees are based on the gross value of your probate estate, not just what's left after debts or mortgages are paid off. Let's say that Lauren dies owning a home in California that's worth $1 million. She also has a $700,000 mortgage on the property. Even though Lauren dies owing $700,000 on her $1 million home, California probate law values that home at $1 million for purposes of calculating the fee owed to the executor and the executor's attorney. Here's how those probate fees are calculated in California. 4% on the first $100,000 or $4,000. 3% on the next $100,000 or $3,000. 2% on the next $800,000 or $16,000. That adds up to $23,000 in fees for just the executor. And the attorney for the executor is entitled to $23,000 as well. That's $46,000 in statutory fees for an estate worth only $300,000. A properly drafted and funded revocable trust might very well be worth the effort for California residents. But a trust isn't the only way to avoid probate. If you want to learn more about probate and probate assets and how to change an asset from a probate asset to a non-probate asset, check out my short video at deathreadiness.com/will, W-I-L-L. Now, let's talk about what a trust looks like. A client recently brought me 2 documents she thought were her father-in-law's trust. One was an SS-4. That's the form you fill out to get a tax ID number for a trust, kind of like the trust social security number. The other was a Schedule K-1, which reports how much income each beneficiary gets from the trust. She was confused, and that confusion is completely understandable. Both documents had the name of her father-in-law's trust on them, so it made sense that she thought either one might be the trust. Unless you've created a trust yourself as the grantor or managed one as the trustee, you'd probably never seen an actual trust document or know what it looks like. A trust is a written agreement between the grantor, the person creating it, and the trustee, the person managing it, for the benefit of a person referred to as the beneficiary. In a revocable trust, the grantor, trustee, and beneficiary are often the same person. That is, until that person dies or becomes incapacitated. For example, if Lauren created a revocable trust, Lauren would be the grantor because she created it. Lauren would be the trustee because she manages it. And during Lauren's lifetime, Lauren would be the beneficiary because the trust is for her benefit while she's alive. At Lauren's death, her revocable trust would become irrevocable, generally meaning that it can no longer be revoked or changed, and the successor trustee Lauren named in the trust agreement would take over. The successor trustee would distribute the assets to the beneficiaries Lauren named in the trust agreement. Those beneficiaries would likely be Lauren's children. Next, let's talk about funding a revocable trust and what exactly that means. Simply creating a trust isn't enough to avoid probate. You actually have to fund the trust. Funding a trust means that you transfer ownership of your property from yourself as an individual to yourself as trustee of your trust. For example, in order to fund my trust with my bank account, I would change the owner of my bank account from Jill Mastriani to Jill Mastriani, trustee of the Jill Mastriani Revocable Trust. Many estate planning attorneys will create the trust agreement for you and then hand you a checklist of the steps you need to take to fund it. You might walk away with a beautiful binder that includes your trust agreement and a nice summary of its terms. But if you don't actually transfer your assets into the trust, it's just a pretty binder. You haven't avoided probate. And even if you're in the small percentage of people who do fund their trust properly, life still happens after that. For example, I might accidentally open a bank account in my individual name, Jill Mastriani, rather than as Jill Mastriani, trustee of the Jill Mastriani Revocable Trust. Or I might sell my house and buy a new one and forget that the deed for my new house should name Jill Mastriani, trustee of the Jill Mastriani Revocable Trust, instead of just Jill Mastriani as the owner. Both the house and the bank account would become probate assets and derail my probate avoidance plan. Bottom line is that revocable trusts are powerful tools when used in the right way, in the right situations. But creating a trust just because someone told you to, without understanding what it actually does, isn't the answer. Avoiding probate might be worth it for you, or it might not matter much at all, depending on where you live and your individual circumstances. And remember, a trust isn't the only way to avoid probate. To learn more about using beneficiary designations and payable on death transfers to avoid probate, visit deathreadiness.com/will, W-I-L-L. Thanks for joining me today for today's Tuesday Triage, and thank you to Lauren for reaching out with such a great question. If you found this episode helpful, I'd love for you to share it with someone you think could benefit from it. And if you have a question you'd like me to answer on a future Tuesday Triage episode, whether related to today's episode or something totally different, send me an email at Jill, Jill, @deathreadiness.com or visit deathreadiness.com/Tuesday Triage. I'd love to hear from you. Next week, I'll be talking about a different kind of trust, specifically the kind people say will protect your parents' house if they ever need nursing home care. You know, the kind that's supposed to prevent the government from taking all of your parents' money. Before you take any irreversible steps, make sure to tune in. This is Death Readiness, real, messy, and yours to own. I'm Jill Mastriani, and I'm here to help you sort through it, especially when you don't know where to start.
Hi, I'm April, Jill's daughter. Thanks for listening to the Death Readiness Podcast. While my mom is an attorney, she is not your attorney. The Death Readiness Podcast is for educational and entertainment purposes only. It does not provide legal advice. For legal guidance tailored to your unique situation, consult with a licensed attorney in your state. To learn more about the services my mom offers, visit deathreadiness.com.